Hello everyone, I'm Professor Paul Carrier, and what I'd like to do now is to cover the issue of contract interpretation. If you are taking my course, this would be in sequence the first class of Contracts 2. In Contracts 1, the primary issues that we dealt with were formation issues, just a little bit of breach, and then the concept of contractual damages, which include the legal kind as well as the equitable kind. Now, once a contract is formed, sometimes the question is, what did the parties mean? If one party has a certain interpretation of an important contractual term and the other party or parties differ, we've got a dispute. And now we have to have rules to determine what legally that term means when you've got more than one possible meaning for it. And very quickly, I'd like to point out two of perhaps the most important interpretation issues. And because they're some of the most important ones, far from the only ones, but these are some of the most important ones, they are very, very testable. And the first thing is, as an interpretation issue, the question of integration, which I will cover in the next following video in the sequence. And integration is the question of whether some things are in a contract or not. Quick example. We talked about an agreement, there it's in place, I sent you an email, the information in the email did not show up in the agreement. And I argue that we meant to have it in, and you argue, no, we didn't intend to have it in. That is an interpretation issue. Does that email, does the information in the email go in the contract, or does it not? Is it excluded? The second major issue, and again, one of many, but one of the more important ones, is when you see a term in a contract and the question is it a promise? I will do my best to paint your garage by Friday. Or is it a condition? I will not pay you if the garage is not painted by Friday. I need it by Friday, and if it's not done, no pay. And you can see in the case of a condition, which we'll cover again later in this Contracts 2 sequence, you could run into significant forfeiture if a party, for example, is unable to paint the garage in my example by Friday. And that kind of forfeiture is certainly possible if the parties are clear. But what if you paint the front of my garage by Friday, and that's the side all my neighbors can see? So technically that's good enough, right? I might say you didn't finish by Friday, I'm not paying. But really, if you finish Saturday but the front is painted by Friday, what's the real problem? Shouldn't I still have to pay you something? Okay, so that's another interpretation issue, and it comes down to the question, is this particular term a promise where breach would still lead to some kind of damages? Or is it interpreted as a condition which might in fact remove the other party's duty, for example, to pay anything at all? So those are the two main contract interpretation issues that I feel are most testable. But now there are many other examples of other terms in the contract. For example, I order widgets from you and I need red widgets. Do I mean red number 4, candy apple red, brick red, fire engine red? And I need a certain kind, but using the term red might have so many different meanings that technically it is ambiguous. I'll argue for one red, and the other side would argue for a different red, and we have to have rules in place to determine how that is done. When you think about interpreting terms in a contract, I would like to emphasize that typically courts do that, and not juries. You can see this as a jury question sometimes, as a fact question for the jury or for the judge if it's a bench trial, but as fact finder, when the main issue is credibility. I said Friday, no, he said Wednesday. Okay, that's a credibility issue, almost more than an interpretation issue. And that being the case, a jury would decide that. But otherwise, what did the parties mean is done by courts, right, not by juries. And I have organized the mechanisms, the tools, the rules to be applied with contract interpretation in a very particular way. What I would like to do is to propose a hierarchical structure for understanding contract interpretation. And I want to be clear that courts have several rules that they can use with regard to interpreting ambiguous terms, and though I put them in this hierarchical structure, I would say that I've never seen a court specifically adopt this structure. In other words, courts pick this rule or this rule based on facts and circumstances that are not always clear. And I'm proposing a hierarchical structure to understand it so that you can determine where a court has made its decision on this hierarchical, not timeline, but within this hierarchical system. Let's start with not a rule. It's kind of a rule, but I'd prefer that you called it a goal. The goal of interpretation, contract interpretation, is to honor the intent of the parties. If the intent is clear from the document you looked at, assuming it's in writing, if it is clear, you don't interpret. You just give it the meaning that you would expect, its plain meaning. When something is ambiguous, however, you have to ask other questions and you look at different sources of evidence. And the first rule, which is relying the least on extrinsic evidence, like prior emails or prior discussions, is the plain meaning rule. So the goal is to honor the intent of the parties, and step one, test one, rule one, should really be plain meaning. Does the term in the mind of the judge or the jury, if it gets to that point, does the term have a clear meaning that does really not need interpretation? And with regard to that, it's possible perhaps to pick up a dictionary. That's somewhat extrinsic, but the dictionary and I both know that candy apple red is this shade, not that shade, as an example. The second rule, the second test, remember, honoring the goal of honoring the intent of the parties. The second test takes a look at some more extrinsic information, and that is Williston's four corners rule. And what that means is that the court will look at the entire document to determine if the entire document in context explains an ambiguous term. For example, in paragraph 4, I ordered 5,000 red widgets. Well, red is a pretty large category. On page 7, 9, and 15, in each case, it said fire engine red. And so I looked within the four corners of the document to understand that red meant fire engine red, fire engine red, fire engine red. So the one time I said red would be interpreted using the fire engine red used later in the contract. And you see that is within the four corners. It's extrinsic to that particular paragraph 3, but it is intrinsic to the entire agreement. And so on my scale, we're going from least extrinsic to most extrinsic. Okay? The third in the hierarchical structure is where court uses rules of construction. And those are simply intelligent, time-tested, and court-approved truisms. And perhaps the most famous is the construction of an ambiguous term against the drafter. If I say red and I mean fire engine red, but the other party who's supplying thinks it's a brick red, which is perhaps cheaper to make, for example, for the same price that I pay, we have a conflict, but I was the one who wrote the document. And so if I say red and I was not clear, that is technically my fault. The problem is my fault. And so one of the rules that courts can use, a rule of construction, is to construe an ambiguous term against the drafter. Now, you're using a rule that's not in the contract. So again, it is extrinsic to this specific contract. But it's just a rule that is time-tested, well-worn, well understood, and in fact logical. Another example, if you have a term and parties are fighting over what the term means, one of the definitions of that term, or the meanings of that term, is legal, and the other one is illegal. You should probably construe it in the form of a legal obligation or a legally acceptable term, not an illegal one, because that would then remove the contract or nullify what's going on. So another rule of construction is, in fact, interpreting logically in a legal fashion when there are two interpretations, one legal, one illegal, use the legal interpretation, okay? And again, you're using rules that are outside of the particular agreement, and that's why it fits on this least to more extrinsic scale. The fourth rule, or the fourth test for interpretation. And a court could pick number 2, could go to number 4, could go through this progression. Again, the framework that I'm trying to impose on the system has not been specifically adopted by any court that I've ever seen, okay? But the fourth is Corbin's, the Restatement Second of Contracts, and the Uniform Commercial Code's holistic approach. And what that means is that the party making the decision on an ambiguous term, which is typically the court, can look at everything: emails, prior emails, discussions, brochures, newspaper ads, and look at everything in context, and taking that, balancing it holistically. What did the parties mean for this ambiguous term? And since you can look at prior emails, for example, you can look at what industries do nearby. You could look at what the parties did last year for a similar contract to see if that helps you interpret the ambiguous term today. All of that is extrinsic to this particular agreement that you're being asked to clarify, or a term within, to clarify a term within. And so again, this fourth test is one step further toward extrinsic. And the final test, if you will, it's not so much a test, it's resort to a system when nothing else seems to work. It's simply to let the jury decide. Here it is. Tell me what it means, jury. Look at these facts. Listen to this side. Listen to that side. Look at these things. What do you believe the parties intended? And in fact, you probably would see that when credibility of the two parties arguing over an interpretation is the issue. Not so much, it's partly the meaning, but you've got two very good arguments and they're opposites. And you have to determine which person, which side of the contractual agreement is telling the truth. So let me sum this up one more time. When you are looking at a case, you can always see where the court makes its decision. It starts with the goal, honoring the intent of the parties. But then the court might go right to the Uniform Commercial Code, Restatement Second of Contracts, Corbin-styled holistic test. Let's look at everything and on balance see what the parties meant, okay? And that's relatively far down the extrinsic scale. But there's no specific rule, at least yet, requiring a court to start at a different point. But going back from 4, a court could pick a rule of construction. I see that an insurance company wrote this contract. We see that the parties are arguing different interpretations. Whose fault is that? Well, the drafter of the contract. So a court could go right to the rule of construction, our third hierarchical step, and end right there. Construction against the drafter, you drafted, we're using the other party's interpretation because it's your fault that this term is not clear as between the parties and their intent. Okay? First test is plain meaning. If the court in its wisdom sees a thing and understands what it means, then could stop. Clearly, one side's arguing this, another's arguing that, but we all know, and I do as a court, I know what this means. Thank you. That's the interpretation. The next test is the Williston Four Corners test, where the court will look not just at a specific term that's ambiguous, but the rest of the agreement to see if other clauses, other information within the agreement will in fact provide the mechanism to determine what the parties intended for that particular term. Third, rule of construction. Those court-approved, court-created truisms that seem to fit. And there are probably 5 to 8 good rules of construction. The most common one, and this is the one probably you should remember, is the construction against the drafter. The fourth is the Corbin-styled holistic test. To take a look at the contract, look at the term in it that's arguably ambiguous, and look at basically everything else that's helpful. And just weigh the evidentiary value of each thing that you look at, okay? So that's a Corbin. And remember, a court could go right to that step, in fact, if it so chooses. After the Corbin-style test, sometimes it's simply a question of throwing it to the jury and see what the jury thinks.